I forgot we weren't doing the intro.
Oh, yeah, we're live, I think, right now. All right. This is going to be horrible, our first time out. All right, ready. So we're doing this different, guys. This is going to be the new way that we're going to do it. It's not going to be screwed up like this, but what we're going to start doing before we do our intro music is we're going to start introing what the live is about, and then we're going to do the intro. So just don't be horrified. We're changing it up. We're trying to play nice with the algo, the YouTube algo, because long intros are not favored at the very beginning of the video. So here we go. How far would you go to protect your child? Would you call the police and wait? Would you trust the system to handle it? What if you already tried that and the system failed? Aaron Spencer is a 37-year-old Army vet, father of two, living on a farm in Lonoke County, Arkansas. In July of 2024, his 14-year-old daughter revealed that she had been SA'd by a 67-year-old man named Michael Fosler, a man that she met through a family friend. Spencer did everything right. He cooperated with police. He let the system work. Fosler was arrested, charged with 43 different counts: SA of a minor, internet stalking of a child, CSAM, possession of. Judge goes ahead and sets $5,000 bond. It's actually $50,000, 10% to apply, with a strict no contact order. And then the system let Fosler walk out of jail. Fast forward to October 8th of 2024, 1:12 in the morning. Spencer wakes up to his daughter's dog barking. Oof. Spencer wakes up to his daughter's chihuahua barking. He checks her bedroom. The bed looks like she's sleeping, but it's a stuffed animal wrapped up in her hoodie. His little girl is gone. Spencer jumps in his truck and starts searching the dark roads around Cabot, Arkansas. His wife calls 911. Then he sees it. A white Ford F-150 turning onto Highway 236, Michael Fosler's truck. And in the passenger seat, his 14-year-old daughter. The same man, the same predator, out on bond, violating the no contact order, fleeing into the night with his child. Spencer pursues for 6 miles, honking, flashing his lights, trying to get Fosler to stop. He doesn't. So Spencer rams his truck into the back of that F-150 and sends it into the ditch. What happens next takes less than 60 seconds. When it's over, Michael Fosler is dead with 15 bullet wounds. And Aaron Spencer is on the phone with 911 saying 5 words that will define his fate. I had no choice. Now, this father, this decorated vet who served in the military in Iraq, sits charged with second-degree murder. Trial starts in 20 days. The prosecution says this was vigilante justice, premeditated revenge. The defense says that this is what a father does in this type of situation. Protects his daughter from a predator that the system refused to stop. So I'm going to ask you again, how far would you go to protect your child? Stick around. We're breaking everything down. This is Defense Diaries, and I am your host, Bob Mata. And as always, joined by my beautiful, brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
Let's get to the intro. little clunky, but I completely forgot that when we hit live that boop, without the intro, we're right there. We're live. I don't know how long it takes us to like get to y'all. So
Well,
I'll
how
have
long were we?
sitting
How
there
long?
silently.
Damn it.
I can hear you
I
perfectly.
know, but all of a
2
sudden I
channels.
can't hear myself in my ears, which I usually do.
Is your volume turned down on the headphones?
Yeah.
Did you turn it up?
Yeah, I turned it down because it was blasting. But just
Can
so
you
all
hear
of you
yourself
know,
now?
a little bit, yeah.
Well, you just got to crank it a
I
little more.
turned it up. Yeah, I did.
Okay.
It took hours, hours. No one could figure out why people couldn't hear me. It was
The one
insane.
channel thing, the one channel thing. Yeah, I think I'm gonna have to like that's gonna be the new thing. Like Ashley History and Homicide sent me a bunch of YouTube tips, which I really appreciated. Thank you very much. I read them today. And
Look,
I
I've been
tried to
telling him to
incorporate.
do this for months.
Well,
So
you actually just wanted to shorten it, which
no, I told you both things that it says that you need to do. Come on now. Mm-mm. No, I'm not gonna stand for that. Gaslighter.
you're fucking nuts. All right, so this is the way we're going to do it from now on. For every live, we're going to have an intro because I guess the concept is when people are scrolling by, that if that video is what's playing, no one's going to stop on it. So we've got to start doing it where we're going to intro what the live's about. So moving forward, we'll get better at it. We'll get better at it, at least in terms of the timing. Like as soon as we hit, but Allie was starting to ask you guys, how long were we on kind of sitting there like morons, not saying anything?
Well, as soon as I sat down, I was like, "Oh, I forgot that we weren't doing the intro." And then you're like, "Oh yeah, we're live."
Yeah, like
So yeah,
I forgot we
how
were doing
long was Bob sitting there?
like a moron. Yeah, like how long was I doing? Hello. Look. I mean, I am very much trained to having the intro, having that extra minute and 16 seconds
Spitfire
to
says,
run 2 to 3 minutes. You're
but
full of
then
shit.
everyone else says 2 seconds.
2
So
seconds. All right.
we'll
All right.
have to rewatch it. We'll have to rewatch it when we end it.
Erica was fucking with my head. All right, so cool. So we'll get better at it, but it's got to be the way to go. We're gonna start doing it like that. All right. So a couple of things. First, I was trying desperately to get a like, share, and subscribe. I have to start telling you guys this at the beginning. That friendly reminder. If you enjoy our content, please make sure that you like this video. Just shrink down that chat, hit that like button, that little thumbs up guy. It helps get it out there. It lets the algorithm, the dreaded algorithm, know that you guys are enjoying the content, which helps us grow the show. And additionally, make sure that you subscribe to the show as well and hit that little bell. That little bell will drop down a menu. It'll say, hey, do you want all notifications every time they're going live? Hit yes. And then you'll never miss a show.
Of course.
Even if you're in bed, you'll still get the notification and you'll know when you wake up that we did a live because it'll be in your notification. So please make sure to like, share, and subscribe. It really helps us. All right, let's get to it. I did start a goal tonight. As you guys know or may not know, Allie and I are going to be attending trial. We're coming to y'all hat in hand to see if you'll help defray some costs. We're going to have to fly down there. Might have to come back because we do have kids. But I need Allie. I need Allie to sit next to me. I think we've come up with the system, if Allie's agreeable to it, when we are going through, because I can't write like Andrea can, and Allie cannot write like Andrea can. I know that for a fact. Not that's legible. Okay.
No.
Because Allie is
I
like,
can't even read my own handwriting
I
after
know, I'm
we got when I
concerned.
went the days that I went to Richard Allen, I couldn't figure out what I wrote.
I'm very concerned about that aspect of it. So the way that we're going to do this thing at trial is anytime there's a witness on the stand, Allie will either handle lawyer or witness or vice versa. So I'll be writing down questions. Allie will be writing down answers
How
or
will we know what answers went with what questions if you're
what are you
I
talking
don't know.
about? You just number it. 1, boop, boop, 2.
Okay. Yeah.
Like, and that'll work when we're gonna actually go over the day in court because we can actually go through, like you ask the question or vice versa, and then I give the answer that the witness give. Just trust me on it. It's gonna work. It'll work.
I gotcha.
There might be
I trust
hiccups, but we'll figure it out. I mean, that's like old school shit. That's going to be like old
I'm gonna
school.
bring a secret recording pen. Just kidding. Just
Shh.
kidding.
Shh. Just kidding. She didn't say that. So yeah. So if you guys can help us hit the goal, we'd massively appreciate it. I figure jury selection is going to start January 26th. We plan on getting down. I've got us flights to get down on Friday. I've been trying to dig around, asking
Wait,
people.
what do you mean Friday? Friday, what date?
I got to do the man on the street shit before leading into it.
Oh, yeah. So, but when's trial?
The 26th, not this Friday, like it's the 26th of January.
Oh,
So
my lord.
it's the last Monday. Yeah, it's coming, baby. It's coming. So, but we're gonna fly down. I'm gonna do the man on the street stuff on Saturday. Sounds like I'm gonna have to hang out at a Walmart. That sounds like that is if there's a Casey's there, I'll definitely hang out there. Apparently in Cabot, there's no malls like where I could kind of just lurk in there and grab people, So there is a farmer's market apparently from 9 to 12. And if weather's good, people do gather there. So, because I want to find out what the actual people that live in Lonoke County have to say about this case. Without me prompting them in any way, shape, or form, the only question I'll ask initially is, have you heard about the Aaron Spencer case? And then they'll either say yes or no. If no, I don't know. Allie and I will have to discuss if I want to engage them in the conversation, give them kind of a synopsis. But the problem's going to be
That would
any
be
synopsis I give will be
right.
biased.
Yeah.
So
You influenced them as soon as you open your mouth. I say we would move on. We suggest that they keep a lookout for it. They check it out. You could still give them a quick synopsis, but not to get their opinion thereafter.
Yeah, I
Just to
think
let them know what I just asked you about.
Yeah, I think because I really want to know, and if you guys have ever seen any of my other man on the street shit, I love doing it. I love engaging people. I don't think Allie will be doing much of it, but she should. It's fun.
I'll
I
engage
like.
people.
Yeah, good. All right, beautiful. We'll take turns. You could be my camera woman, and I'll be your
I
cameraman.
don't know about that. It depends what the lighting is out there.
Oh my god, it's gonna be daylight, so you
All
can't
right.
be
As long as you got the sun wherever it's supposed to be. So
daylight. I'm gonna always have to make sure you're never backlit. It's always gonna be the light's gonna be facing you so that it's
yeah.
like okay, all right.
Or I'll
So
carry
do the
around a
ground
hat
rules
with a light on me.
is like I'm sure there's shit like that exist. So okay, so that's kind of where we're at. Yes, we did hit 60,000 right before Christmas. We thank you guys so much. We are
Yes,
going to
thank
have a
you.
celebratory little party, 60,000 party. And yeah, dude, I'm already freaking out about Saturday. But I'm ready. I'm ready for it. Like there's this thing going through my mind. If we lose to the Packers, our most hated rival, does it wash away all the greatness that went on this season? And it kind of does.
No, don't think like that.
Nah, man, it's like you don't understand, babe. It's been like 40 years of
Yeah, I
hell.
was thinking about that the other day. I was like, damn it, why do they have to play the Packers?
Yeah,
And
well, that's what I'm saying. If we lose to those guys in the playoffs, then are we going to be doubting whether or not Ben's this guy that we think that he is? Are we going to be doubting that Caleb is the guy
I'll
that we think that he is?
I'll tell you what I doubt, that most of the people in this chat wanna hear this conversation right now.
Yeah, that's true. That's true. But Allie
All
did
right.
do her first Bears game. All right,
I did.
so lead them into it, baby. Let them know what we're going to get into.
All right, so we've got a bunch of orders. I don't know if Bob just wants to summarize the orders or not, but we also have a motion to reconsider that I find very interesting. So when Bob comes back, I guess we'll decide together which we're doing first and what what we're going through.
Well, I think it makes the most sense to do the orders. They're quick, they're short, and it makes more sense to go through a motion to reconsider if we've read
I
the
just don't think you
orders.
need to pop up every order, but it's up to you.
I'm going to pop them up.
Just save the one that deals with the issue that there's a corresponding motion for.
Okay. And if I pop one up that you're like, meh, I'll pull it. That's all. Won't be that bad. So the first thing that came out that I'm going to share is this. So this was a non-resident attorney who joined
There you go.
Aaron.
I'm saying, Matt.
All right. So
Just tell the people about it.
okay, so Nadia Stagg, who is a non-resident attorney, obviously she's an attorney from a different state, has come in and made her pro hoc application. And I think that she filed this prior to her application being approved. So she's from Minnesota. She's got more than 15 years of experience, including 8 years with the Office of the Public Defender handling capital habeas cases. She's been admitted to practice in the federal courts of Arkansas since 2019. So she's highly skilled. She's got a lot of experience and sounds like she's a fine addition to the team. She gives her info there. She has not been subject of disciplinary action by the bar or courts of any jurisdiction in which she's licensed, and she has not appeared in any Arkansas cases. And I think that she's like got a gig with Aaron. So so she's agreed to serve as associate local counsel and provides the attached affidavit. So there you go. So I think she is
That'll likely be,
granted.
it'll likely be granted.
Okay. And then this was filed on the 16th. This was an order allowing a blended pretrial proceeding. So basically, this says that before the court come the parties' joint motion for a blended pretrial proceeding on December 17th, which already took place. That was a day of, there were actually 2 days of a lot of motions. And those were all ruled on when we start getting into these orders. Because I had some people send me some excellent notes regarding the motions that were argued. And there were a lot of critical motions to the case in terms of kind of the bigger picture stuff, in terms of what's going to be admissible and what's not, in terms of experts, in terms of video, critical things. Many of the motions we had gone through previously, and now they came to pass. So this is the actual motion, and it's talking about the matter was set for a pretrial on the 17th, and I guess in civil hearings and non-jury trials, they are conducted as virtual or blended, meaning they incorporate some Zoom in there. So I'm assuming what happened is they allowed some witnesses to appear via Zoom, which Judge Gall did not allow. So, I mean, I guess this judge is a little more reasonable than Judge Gall.
Wait, is this the motion or the order? I thought she denied a Zoom appearance for something.
Maybe she did. Let me see. No, Judge Elmore granted it. So no more than one witness by Zoom per party. So she limited it. Okay. So, all right. So that took place. And on the 12/19 of 2020.
Make those bigger, love. No one can see it. What's the point of having it up?
Trying. I'm whipping through them. All right. You want to read that one? I'll scroll.
All right. Order allowing cell site and cell site evidence. On December 17, 2025, this court was presented with testimony on cell site location evidence. The court, having considered the defendant's motion to exclude the state's proposed cell tower and historical cell site location evidence. So now, just to give a little bit of background as to what this was all about, the state wants to get in all of Aaron Spencer's cell site data and location information to try and establish that he was using the phone at certain places and he could have called the police or he could have called someone different. And I believe it's completely irrelevant. And I don't think that it can pinpoint a location enough to be relevant, because it has to have some probative value to be relevant. When it just gives like a general vicinity, I don't see how that is relevant. And I also don't see how it's relevant in this case, because I don't think it matters one shit whether he could have used the phone, whether he could have called the police. It doesn't change the situation at all. So, but that's what this order is going to. The state sought to get it in. The defense sought to exclude it. So the order goes on to say, the court has considered ARE, so Arkansas Rule of Evidence 403, while this type of evidence is not precise, I mean, that's the understatement of the day, it may assist the
shit.
jury in understanding general movements or proximity during relevant time periods when limitations are clearly explained. The court will not permit testimony suggesting that cell tower evidence establishes the exact location or pinpoint accuracy. Aerial photographs in the cell site document provided to the court shall not be allowed. For these reasons, the defendant's motion to exclude is denied. The cell tower and cell site evidence will be admitted, subject to the limitations that it may be offered only to show general tower connections and coverage areas, not precise locations.
Yeah. What is the value? What is the value of that? I
Zero. And by the way, that's what Rule 403 says, that it deals with the relevancy of evidence and whether evidence is more probative than it is prejudicial. And the court's finding here it's more probative. And Bob and I are questioning, what the hell is it probative of?
Right.
It's not probative of shit.
Right.
So we'll see how the state uses it.
I mean, it harkens back to Zach Adams, and that bullshit where there's not going to be many towers in Cabot, Arkansas. So in terms of they're not going to be able to narrow his position. And even if they were, we know where he was. We know where he was driving. We know where he rammed Fosler off the road. We know where all this shit went down. I just don't, to me, it seems completely prejudicial. Serves absolutely no value whatsoever.
Right. And now the order on the motion to dismiss, the defense sought to dismiss the charges, the indictment, because they filed it through an information, and there was no preliminary hearing, nor was there a grand jury. And yes, even a grand jury will indict a ham sandwich, so be it. But at least there's some attempt at a checks and balance there. But the court says that the Arkansas Constitution and applicable state law recognizes that individuals may be charged the filing of an information by the prosecutor. The court shall not swallow the rule of Arkansas law. Odd turn of phrase there.
Sure.
Therefore,
is.
the court hereby denies defendant's motion to dismiss.
That is a very odd turn of phrase. It really is. I want to jump back to here's the only thing that I can think that they're going to try to do, and it's based on some of the motions that they've filed, and I'm talking about the state.
You're going back to the cell tower?
Yeah, like you don't even need to pull it up. And I don't know why you quit sharing that.
Well,
but
just because we weren't talking about that anymore.
All right, so but real quickly, the thing that I think that they're going to try to do is that they're going to be trying to create this narrative that Aaron Spencer, they're gonna incorporate his cell phone records in terms of the things that he wasn't doing, like namely not calling 911 with where he was locationally, but they're not going to be able to do that. They're not going to be able to say, here he was 3 miles away from the scene, and 3 miles, why isn't he calling 911? Like, that's the only thing that I can think that they're going to do with it. And to me, it's just a bunch of bullshit. Like, it's not going to matter.
Right.
All right. So this is the next one. And this dropped on the 29th, right?
So this one is the one that I want to save because there's a corresponding motion.
Okay. Wait, is that, so right before we do the motion?
Yeah.
This might have a corresponding motion as well. Is this one of the other motions to reconsider?
I got stuck researching the other one, so I'm not even sure.
So that's Carrie Landau. All right. So
yeah, it is.
It might be. So let me see. All right. This order, that's reputation.
So maybe that's all of them?
Okay. Well, yeah, this is relating to, is that Jefferfer? That's supposed to be Jennifer, right? Maybe. I don't know.
I can't see the top. What is this order?
This is for order on expert witnesses. So one of them is indeed Carrie Landau. The other one is Jefferfer Steele. Is that a real name?
So let's do, because I haven't read that motion yet. So let's do the other one first.
Okay. Well, let's get through the orders real quick because I think there's only
Okay.
2 motions to reconsider. All right. So this is an order denying remote testimony and requiring in person. So she's for the trial is not allowed. She's pulling a gull.
Okay, so what was the other one for?
It was for the day of hearings on the
Oh,
17th.
there's a day of hearings.
Well,
Okay.
it's come and gone. It's
Oh,
come and gone.
so we missed it?
Well, I
Or they're
mean,
not
we're
are
going.
there
Yeah.
cameras?
No. That's why we're
Oh,
going. That's why we're going boots on the ground. There's no cameras.
that explains why there's stuff that we don't know that I was like, "Wait a minute, I don't understand." Okay, sorry.
Correct. All right. So this is the order denying remote testimony and requiring in person. It's pretty self-explanatory. The parties previously requested witnesses' testimony by Zoom after consideration of the previous hearing in which Zoom was used, and after considering the nature of the proceeding, the court finds that in-person testimony is necessary to one, ensure that the witness is not being coached or influenced. Valid point. Prevent exposure of extraneous information. Another valid point. Preserve the solemnity and the integrity of the judicial process, and the defendant's rights under the Constitution Confrontation Clause are paramount in criminal trials. So she denies that.
No, I
And
mean, I just have to say, I hate Zoom testimony for a criminal trial as opposed to like a hearing, this and that. Yeah, like, look, if something comes up and it's necessary, like it was in Richard Allen's case, and there was like a legitimate like sting that popped off, and you
yeah, like the
know,
guy would die if he got on a plane. Like he had
right,
something where he
and I
couldn't
think he
fly.
was like law enforcement or former law enforcement, so FBI, so there wasn't much risk that he was going to be coached or influenced by someone on the side, like telling him what to say. But as a general rule, I hate it, for all those reasons. If I need it, then yeah, I guess I don't hate it.
Yeah. I mean, look, that was always our concern when they started Zoom court back at the beginning of the pandemic after they closed the courts down and then discovered Zoom was a thing. And then all lawyers around the country started doing Zoom court. And then obviously every, time that we have to be into court isn't a simple status hearing. Sometimes it's an actual hearing. And Allie and I were very much against the concept as defense attorneys of allowing people to be on Zoom because you don't know who's standing behind the camera, holding up some shit, a script, or that extraneous evidence that they're
Or if they're reading their notes,
like
right, something they
whatever,
wrote out
anything,
ahead of time,
right? Any of that stuff, you need to be able to see that person in court on the witness stand
their
because
whole body.
the whole thing, got to watch all that shit. So all those guys who do the content about body language have the ability to have some content to put out. I mean, what would we do if it was all Zoom? All right. So this next one is an order requiring timely submission of juror questionnaires, voir dire questions, witness lists, and identification of expected family members. All right. So that's pretty self-explanatory as well. Everything's got to be turned in terms of juror questionnaires by the 14th of January, and proposed
Proposed
voir
voir dire.
dire will be
So,
turned in by the 19th.
are we getting the sense that the lawyers aren't going to question the prospective jurors themselves, or is it
I don't know.
so sometimes they have some questions they want the judge to ask and then some that they're going to ask, and I just find it odd if they're making them the lawyers write out all the questions they intend to ask ahead of time because, it's fluid. It's a fluid situation.
Oh, wait, yeah, Tracy. Oh, did you remove the ornament
Yeah, it's
thing?
done,
Okay,
done.
cool. All right. So the court will review, modify, approve, or reject all proposed questions in the dissertation. Only questions approved by the court shall be asked of the potential juror. So it makes it
Wow.
sound like the lawyers are going to get to ask it, but the judge is going to make sure she knows every question that's going to be asked ahead of time. The court may conduct voir dire itself. So there's our answer. And may limit or prohibit counsel to conduct voir dire as necessary to ensure fairness, efficiency, compliance with the Arkansas rules of evidence and case law. In this case, that makes sense to me,
What?
because it just does. Like you're going to have to really walk because you can't indoctrinate potential jurors.
Well, you got to trust the lawyers to know what they can't do
I'm
and
just
tell them what they
saying, like,
can't do and then not do it. But to prevent them from
oh, this is like
establishing a rapport with the
the the
jurors.
the world's most habitual line stepper
Oh yeah,
over
that's
here
me.
saying that shit. Come
Still,
on, dude. You pushing the limits. Wait
fuck
until
yeah,
they shut you down. Come on.
hell yeah.
Yeah. Well,
But
there you go.
still, she's got to trust the lawyers until they do that.
Yeah.
And it's a big deal to prevent that initial, you know, what did I just say? Establishing a rapport with the jurors.
Yeah,
You
no,
know, it's
100%.
important.
I'm with you. I'm with you. But I don't think that
And
those are the types of questions that are going to be at issue. It's more
yeah, but if you
indoctrination with the facts of the case, kind of getting into that, like, like they're certainly going to ask jurors, have they been essayed, or has anybody in their family been essayed? Those kind of questions will come out. Like typically the judge will ask those questions without
well,
the lawyers even getting into them.
yeah, but
Um,
the problem is this says that the judge might do it all and not let the lawyers do it.
that's not the way I
And
read it.
that's for poor, yeah, or may limit or prohibit.
Yeah, I mean, I think that's if they keep fucking up. Like I think initially she's going to allow it, and then if they step over the line, man, she's going to pull it back in. I mean, that's the way I view it. But we'll see. We'll be there. We will be there to tell you all the blow by blows of how this shit goes down. I don't know if we'll be allowed in for voir dire or not. I'll try to find out ahead of time because that may push, but I think that they'll get a jury picked in a day here. I do. So each party shall exchange a final witness list identifying all witnesses the party reasonably intends to call during the trial. The witness list shall include the full names of each witness with all experts, a brief description of the witness's expected testimony. The party shall follow all criminal rules. Absent good cause shown, no witness not disclosed in accordance with this order shall be permitted to testify. Identification of expected family members that will attend the trial in order to maintain courtroom security and to address any issues related to seating or emotional displays before the jury's said list shall be given to the court on or before 12th of January. This requirement is administrative only. The information shall be solely for the purposes for courtroom management and security. Yeah, I got to find out how big that courtroom is.
Yeah.
God, dude, I hope we don't have to stand in line. Selection of jurors. The parties in the court agree it is in the interest of the administration of justice that voir dire shall consist of a limited number of potential jurors at a time.
So we discussed this before, and the judge initially gave like a vague order and never really said if she was going to have a very small jury pool. We talked about how jurors are asked questions in front of other jurors. So if somebody comes out and says, "Oh yeah, he should have killed that, you know, R-ing son of a bitch," or something that would be, against the defendant, you say it in front of all the jurors, you poison the whole jury pool. So smaller numbers prevents that from happening. So it looks like the judge kind of reconsidered that.
Yeah. All right. And then we've got another order here. So this was a big one. So this is the order admitting the defendant's prior statements on this day after reviewing the motion response, having heard witnesses' testimony and arguments on admitting defendant's prior statements. The court finds that the defendant's statements are relevant under Arkansas Rule of Evidence 401 because they bear directly on the defendant's intent, motive, and state of mind preceding the charged offense. So this is pertaining to the body worn cam footage of the cop from back in July when Aaron found out that his daughter had been essayed. And that was this, this is where he's talking about taking the law into his own hands and, the system can handle it. And he said something like bullshit. So that's coming in. Defendant's own statements reflecting hostility, intent, or attitude are admissible to assist the jury in determining intent. To the extent the statements reflect the defendant's view about resolving disputes through personal force, they are admissible for non-character purpose under 404B, including proof of motive. God damn it. I got to get up. Hold on. Do my scrolling. Proof of motive, opportunity, intent, preparation, plan, knowledge, identity, and absence of mistake or accident. Any lapse in time between the statements and the charged offense affects the weight, not the admissibility of the evidence. Finally, under Arkansas Rule 403, the court finds the probative value of the statements is not substantially outweighed by the danger of unfair prejudice. The statements are the defendant's own words and are highly probative of his mental state. Disagree.
I mean, I could not disagree more because of the facts of this case.
Right.
The guy kidnapped his child or left under darkness with his child and tried to evade the father. So if he had just ended up dead in his house on the street, different. Okay, fine, get it in.
Right.
But I don't care if he wanted him dead. The law doesn't care if he wanted him dead. All the law cares about is, was he justified in his actions that night, regardless of if he was just waiting to kill that motherfucker.
Unless they're trying to come with this was all some kind of planned scenario.
He somehow planned this guy to kidnap her, to take her.
I don't know. I have no idea.
Here's the thing. He somehow convinced this predator to come to his house and leave with his kid so he could kill him.
I mean,
okay, state. Luckily, I don't think it's going to matter.
Right.
No jury is going to convict this man, in my opinion, and I don't think that's going to make the difference. It might make it, it might make deliberations a little bit longer while somebody's, tossing that out there before they get convinced otherwise.
Yeah. I mean,
but I call bullshit.
Yeah, I'm calling bullshit on it too. But I honestly don't think it's going to matter. All right, so we're to the motions to reconsider, okay? And this is the order allowing opinion and reputation of the deceased. So on this day, after reviewing the motion response and the hearing arguments of counsel, the court doth hold. Wow. One, that the court finds the defendant has raised self-defense under Arkansas Rule of Evidence 404A2. The defense may introduce reputation or opinion evidence regarding the deceased's character for violence in the community. And two, specific acts of the deceased not known to the defendant are not relevant to the defendant's state of mind. Therefore, specific acts are not allowed.
So Bob and I are perplexed by this because I'm assuming that the defense spoke to some specific acts that he damn well did know about and would therefore be admissible. But the judge is saying, making a conclusory statement, if he didn't know about them, they're not allowed. So no specific acts are allowed. Does this not cover the specific acts against his own child, which we cannot say are not acts of violence?
I mean, if that's the ruling, that's
so
insane.
Check your texts, by the way. So I did a lot of research into this because there's two different sides of this. One is reputation evidence in the community. So that goes to whether someone has a reputation for violence, is known to be violent within the community, such that the defendant, could have learned about it or no, let's take that out of it. So in the community, such as it would support the defendant's position that that person was the initial aggressor, that the defendant was the initial aggressor. So in that situation, you can't put in specific acts. You can just get in that in the community, they have a reputation for violence. They have a reputation for being dangerous. They have a reputation for being physically aggressive, for, things like that. Now, clearly, based on this motion, the judge must have said orally, because it's not in that order, that she was limiting the reputation to the reputation in Lonoke County. And that is what this motion is about. I don't see anything in this motion saying, well, wait a minute, we do have information about specific acts. So why are you saying that they're all excluded?
I mean, the question I have is during the hearing, did it come out like if this is me and you and we find out about this in July and then the guy's arrested, like we're going to be digging into this fucking guy. You know what I mean? It's like which
Right,
then becomes knowledge.
right.
So you know, I mean like I don't know if they got into that or not. But, like, I would think that they did. I mean, in the days of the internet, we have access to a lot of information, and I'm sure some digging was done. I'm sure people were spoken to. I'm sure people were reached out to and reached, into the to or out to the
But
Spencer family. I
you
To
would
me,
assume if
it's
any
strange.
of that existed, it'd be in this motion,
Right. All right, well,
and
let's
it's
go
not.
through it.
All
Okay.
right, motion to reconsider limiting 404A2 evidence about decedent to his reputation in Lonoke County. Comes now the defendant, Aaron Spencer, by and through his attorneys. And for his motion, he states, following a pretrial hearing in the above case on December 17th, 2025, this court ruled that, that the defense would be permitted to introduce evidence pursuant to Arkansas Rule of Evidence 404A2 regarding opinion or reputation testimony as to the decedent Michael Fosler's character for violence. However, this court limited any 404A2 evidence to testimony about Fosler specifically in Lonoke County.
It's whack.
So, Arkansas Rule of Evidence 40402 authorizes the admission of evidence of a pertinent trait of character of the victim of the crime offered by an accused or by the prosecution to rebut same, or evidence of a character trait for peacefulness of the victim offered by the prosecution in a homicide case to rebut evidence that the victim was the first aggressor. Arkansas Rule of Evidence 405A explains that in cases in which evidence of a character or a trait of character of a person is admissible, proof may be made by testimony as to reputation or by testimony in the form of an opinion. On cross examination, inquiry is allowable into relevant specific instances of conduct. Arkansas Rule 405B explains that in cases in which the character or trait of character of a person is an essential element of a charge, claim, or defense, proof may also be made of specific instances of his conduct. Neither 404 nor 405 or 405 mention the word community. Where character evidence is offered in support of the contention that the decedent was an aggressor or to characterize and explain his acts, the defense is restricted to proof of general reputation in the community where the defendant lived. Okay, so that's just going to, was he the aggressor or something about his behavior? It's not the mind of the defendant. That's separate. So it goes on to say every fact that would be competent evidence in a case of self defense by a person defended is competent where the killing by the accused is alleged to be in defense of another. No case has interpreted this to mean where the defendant lived at the time of his death. Consistent with Rule 404 and 405 in a justification case, specific instances of conduct of the decedent not known to the defendant are not admissible unless on cross-examination. The court's case law regarding specific instances of conduct within the knowledge of the defendant, Rule 404A2 and 405, makes clear that there is no limitation to the specific community where the decedent lived at the time of his death. And 1977, reversing they quote a Arkansas case, reversing murder conviction because the circuit court erroneously precluded the defendant from introducing evidence he was aware decedent had killed people in another state. It would make It would not make logical sense to restrict opinion/reputation testimony to only the decedent's community at the time of death. This evidence is relevant as probative of who was the aggressor when a defendant asserts that he was justified in killing the decedent. Limiting the rule to an opinion or reputation of the decedent in a small community where he lived at the time of his death could narrow the rule's application to nothing where, for instance, a person acted violently only outside the area where he lived, moved frequently, or did not have roots in a particular community. It also makes it unclear what, quote, community refers to. Is it a county, the city in which the decedent lived, the state, or a larger area that he frequented? Does it include an area he frequently visited or spent overnight? Limiting 404 evidence, as the court has done, does not comport with the purpose of the rule. A person's reputation in the community does not change merely because they happen to leave that community. A violent person is still a violent person, even if they move out of state, just as a peaceful person is still a peaceful person, even when they leave town on vacation. Foster's reputation for violence and aggression in the communities in which he lived is admissible, whether that was in Indiana, Arkansas, Pulaski County, or Lonoke County. Moving somewhere to get a fresh start does not absolve one of the reputation in the communities in which they lived up to that point.
Good
A
point.
Lonoke County jury will be sufficiently able to give any evidence of Foster's reputation in communities outside Lonoke County, communities in which he spent substantial portions of his life, the weight such evidence is due. Thus, the defense requests that the court reconsider its ruling limiting Spencer's admission of 404A evidence and permit reputation and opinion evidence from people in the communities in which Foster lived, not only Lonoke County. Wherefore, the defendant, Aaron Spencer, respectfully requests this court reconsider its ruling limiting 404A evidence regarding the decedent to his reputation in Lonoke and for any and all proper relief which he may be entitled. So now I've done some research, and I'll start with a Supreme Court of Arkansas case from 1981. And whoops.
And while you're pulling that up, just so you guys are clear, what we just read is what they call a motion to reconsider by the defense based on the court order that we read preceding that motion. So the court limited it. Aaron and Michael said, okay, we got to file a motion to ask her to reconsider it. We're going to make our argument. We'll cite a little bit of law and we'll see if she changes her mind. So that's what we just went through. Now Allie's going to back it up with some law that she found.
The law that was missing, in my opinion. Okay, so this is Arkansas Supreme Court. Evidence of a victim's violent character, including evidence of specific violent acts, is admissible where a claim of justification is raised. Such evidence is relevant to the issue of who was the aggressor and whether or not the accused reasonably believed he was in danger of suffering unlawful, deadly physical force. Wait, no, I don't know if this is the one that says. Okay, so this is not the one. So that's first. And clearly they don't appear to be disputing that. So now this is also the Supreme Court of Arkansas. It's from 1977. And I don't know if I highlighted it. So, whoops. Wait. Come on.
All right, while you're looking, I'm going to throw up a couple of these.
Wait, no, don't throw up anything. I've got. Oh, I see what you're saying. Sorry.
Okay. Cuddle Monster's mom. Give the guy a gold medal from me.
Here it is.
Indeed. All right. Thank you
so much.
So
this is Arkansas Supreme Court, 1965. The general prevailing rule is that testimony to prove the good character or bad character of a defendant in a criminal prosecution must relate and be confined to the general reputation which such person sustains in the community or neighborhood in which he lives or has lived.
Now that's to the defendant, though.
How would that be any different? How would that be any different under the law is going to treat that the same? The reputation. Yeah, good or bad character of anybody should be the community should be defined the same.
Yeah, in terms of the community, yes, I agree.
Right, so
If
in
you're
which
talking to it specifically as to that point,
such person sustains in the community or neighborhood in which he lives or has lived.
including out of state? I wish they would have put that last sentence there to really clarify for us.
No, absolutely. And then, there's other cases in um darn it, I don't know if I pulled them all up. So I'm just going to read what I pulled. So, there have been federal cases that have been talking about how you have to, uh, that this is not, and there's actually an Eighth Circuit case, which is what they're in. I My computer's going crazy. I think this is it. Um, okay. All right. So yeah, I'll pull this up. Okay. So here, and this is Arkansas circuit, but it's federal law. We find the court erred in excluding their testimony as to the reputation for truth and veracity and requires a new trial. Now, the rationale for limiting reputation testimony to the community in which he lives is to restrict evidence to repute to reputation among people who know the person best. However, this rule must be applied in a realistic and practical manner. Professor McCormick observes, but as an exclusive limitation, it would not be appropriate in this country today where a person may be little known in the suburb or city where he lives, but well known in another locality where he spends his working days or in several localities where he does business from time to time. Thus, today it is generally agreed that proof may be made not only of the reputation of the witness where he lives, of his of his repute as long as it's general and established in any substantial community among of people among whom he is well known, such as the group he works with, does business with, or goes to school with. And there's I read some other cases, and this might be one of them too, um, where they say that this rule, and let's see when this is from, by the way, 1973, okay? And they're already acknowledging that. Now, there were several more. I think this is it. Um, Actually, this is a good one.
I feel like, yes, I feel like the kid's gonna have to testify, but
Okay. So they said that the trial court erred in permitting the state to present testimony of this was about to like business people. But anyway, they said in Swenson, this court concluded that testimony regarding the defendant's reputation for veracity within the church was improper. Instead, evidence concerning the defendant's reputation should have been limited to that in which the community which she resided. The Swenson court did not explain the reasoning behind this. That red flag there shows you that it has been reversed, um, stating only that it required by the rather strict rules governing character evidence in this jurisdiction. The state argues that we should reject this language from Swenson and adopt a more functional definition of community, parallel to that adopted by the federal courts in interpreting Rule 608. For example, in one federal case, the court held the realities of our modern world necessitate a functional approach to reputation evidence. We also think there should be no restriction necessarily limited to the community in which the witness sought to be impeached lives. and that the realities of our modern, mobile, impersonal society should also recognize that a witness may have a reputation for truth and veracity in the community in which he works, and may have impressed on others in that community his character for truthfulness or untruthfulness. A number of states and federal courts have adopted a functional understanding of community.
And again, this is 1993 case. We've come
This one
light
is too?
Yeah, yeah.
Yeah.
So,
So
like, I mean, this is like pre-internet, at least pre-internet, to where we all had access to it.
right. So it says, given the tremendous changes in demographic patterns since the Industrial Revolution, however, it is doubtful that limiting reputation evidence to the community where one lives still serves the purpose behind the rule. People often live and work in separate communities. Mobility between communities has also increased, limiting the depth and duration of one's contacts to a residential community. In fact, a rule that limits reputation evidence to the community where one lives may undermine the very purpose behind Rule 608. So there's tons of cases out there that say this, but what I just find most surprising is that in 1965, the Arkansas Supreme Court said it includes, where they lived or have lived.
Yeah.
So I looked at a lot of that. I also looked at, the specific evidence. We talked about that going in. You can have specific acts, and the judge acknowledges that you can when it goes to, again, there's two prongs. One, whether the victim was the aggressor. And for that, you can use reputation and character evidence, general reputation and character evidence, but nothing specific. When it goes to the mental state of the defendant, you can use specific acts known to him. And it seems from this motion that the defense is not asserting any.
Well,
and I'm assuming the judge excluded the ones we know about. I'm just assuming that, like the ones.
I hope you're right, because that's the $1 million question. If there is, so, and I don't know if it's noted in this motion, but when I got the handwritten notes that were typed out in terms of the 2 days of hearings, the judge, good old Judge Elmore, was quoted as saying, "Is this case has nothing to do with SA," like said those words. So that's a scary prospect to think that that's where her head's at. I mean, what is she talking about?
Well, that's a good segue into the next order and corresponding motion.
All right. So the next order, order on expert witnesses. And again, this was dropped on December 29th. And here, let me get it on to scrolling. All right. The defense has given the state a list of individuals they wish to call as experts, and the state has provided a motion in limine. The court heard arguments on the issues at the omnibus hearing, and the court then stated that some of the witnesses would not allowed to be testified.
Let me just pop in. Omnibus is just a fancy word for, like, we considered multiple things at the same time. It included numerous issues.
Okay. The court shall clarify: one, listed defense witnesses Jefferfer H. Steele and Carrie J. Landau. Testimony will confuse the issues in this matter and would not assist the jury in this trial of homicide. Two, based upon the information provided to the court, Dr. J. Consulting, their testimony would not assist the jurors and would only confuse the issues. Three, Clint Norris may qualify as a crime scene expert. The information provided in defense response indicates that he may have the sufficient training, education, and experience in crime scene analysis and or reconstruction to qualify as an expert under Arkansas Rule of Evidence 702. The proposed testimony concerns technical matters beyond the common understanding of jurors. However, no witness would be allowed to offer opinions regarding the credibility or truthfulness of any witness, including law enforcement officers.
So wait, I have a question there.
Yeah.
If his testimony basically impeaches what law enforcement are I guess, assuming it's like I don't get that, because the whole purpose of an expert is to call into doubt something that the prosecution has presented by some form or fashion. So what the fuck is she talking about?
I don't know. Because the other part of this, don't forget that they had moved to they wanted some kind of remedy under the law with respect to the lost micro SD card from Fosler's dashboard cam. And we heard that whole fucking fakakta story about how he pulled it out and then he put it into a converter and stuck it into his computer, and he watched the videos, and the videos just showed the red and blue flashing lights, and there was nothing else on there. And then he stuck it back into the fucking dashboard cam and transported that through another cop to the AG's office for them to review it. And when the AG's office opened it, there was no micro SD card. So, in terms of why can't he testify as to proper procedure in that particular circumstance? Because
Well, I think what I would have liked to have is an
that's a
expert.
trust me, bro situation.
Yeah.
Like we're supposed to believe this cop on what he saw on these videos. It's lost evidence. And in theory, Aaron and Michael provided actual knowledge that I'm assuming that they got from one of their experts on how these dashboard cams actually operate.
And that's the expert I would expect to be seeing a trial, to say what would have been on it, and then that it's not there.
Right.
And even if they don't get an instruction, I does that prevent the defense from arguing it?
I don't know. I mean, the entire point of those dashboard cams is that if you were in a collision, the thing's going to pop on. I mean, that's you're using. They were made for liability, and they were made for use in courts to show what happened. So like, especially where you have an incident where he's hitting Fosler's truck, there's been some kind of contact made with the vehicles, and theoretically, everything that happens after that should have been caught on that dashboard cam. Like, to me, it's insane that it wasn't. And I'm not buying what that cop is selling. And it seems awfully convenient that SD card has vanished like a fart in the wind. It's crazy to me. Like,
But I don't know that these experts encompass that,
I don't know either.
because
I don't know
this is
either.
a doctor.
Well, no, there were a couple.
Clint Norris.
Clint
Oh, yeah,
Norris.
he's not a doctor.
No, Clint Norris is the guy. He's the crime scene guy.
Yeah,
He's
but is the crime scene guy also the expert on that device?
I don't know.
Right.
Probably not. Maybe though. I don't know. I mean, if I'm a crime scene guy in this day and age, I'd get proficient, since those are pretty commonplace. All right. So B, she goes on to say, state or imply that any witness lied, fabricated evidence, or acted in bad faith. So she seems to be talking specifically to that.
Yeah, but that's not fabricating evidence, that's destroying evidence. So what is the fabrication?
Or acting in bad faith.
Yeah.
That was like,
I
that was
wonder if
one
there
of the
was
things that they had to show.
I wonder if there was something else that was sort of
Not
brought
that I'm
up
aware of.
that speaks to fabrication, because she didn't. I mean, why wouldn't she use the word destroyed evidence?
I don't know. All right. C, offers legal conclusions, including whether the defendant acted reasonably, lawfully, or in justification. D, express opinions on the ultimate issue of guilt or innocence.
So C and D go hand in hand, and that's typical. You can put the breadcrumbs out for the jury to decide, but the expert doesn't say, and because of that, it's clear that Aaron Spencer was justified in killing, or it's clear that this guy was the aggressor. You just
Right.
tell them what happened, and you could be describing something that makes it clear that he was the aggressor, but you don't say the words, and therefore I conclude he was the aggressor.
Right. 4, the court will strictly enforce these limitations during trial. Counsel is instructed to advise the expert of these restrictions prior to testimony. Any violation may result in exclusion of the offending testimony or other appropriate relief. So the state's motion is denied and granted in part. Court finds that allowing the expert testimony within these parameters preserves the defendant's right to present a defense while ensuring compliance with the Arkansas rules of evidence.
So this
So
wraps up to what Bob was saying earlier, that the judge was noted as saying what, babe?
that this case has nothing to do with SA.
So because the part of the thing that they wanted to present expert testimony was about grooming and how grooming works, how a predator, can manipulate his victim so that they're doing what they say without physical force. Now, in my opinion, I thought that testimony is unnecessary and actually damaging to the defense. I don't think we make it about that at all. All that matters is the Aaron Spencer's state of mind. His child is missing. The dog was barking. When he sees his child with Fosler in the vehicle, it all clicks that this guy, kidnapped my daughter. And
Right.
whether she left willingly or not shouldn't really make a difference, but it leaves his mindset that she was taken from that house as a possibility.
Right. Well, and that was my argument. You and I had a pretty spirited debate about this and whether or not I thought that this was relevant and helpful to the jury, because and I agree with you, and I've said it, to me the clock starts in terms of when this thing should be looked at, not as to when the child either leaves the house or is taken out of the house, but the moment that Aaron Spencer sees Michael Fosler's truck with the kid in the truck. That's
Right.
when the clock starts for me.
And how
Nothing prior to makes a bit of difference to me. The clock starts at the minute that because he may be suspicious that she's in Fosler's truck, but he doesn't know. He can't know until he knows. He may suspect it, but he doesn't know until the minute that he knows. When
or he may
confirms
fear it.
he could any of those things. He
Right.
fears it, suspects it, whatever. But he doesn't know until he knows. And then when he knows, when he sees her with his own eyes in that truck, to me, that's when this whole thing starts. That's when you run the clock from.
Right.
Nothing prior to. But we know that the state is going to come with this bullshit, that she left willingly, that they were in some kind of relationship, that she left the house with him. If that's what they want to go with, good on you.
The defense should have moved to exclude any reference of that, because how she actually left the house is irrelevant. It's only what was reasonable for Aaron Spencer to think.
100%.
Period.
100%.
And that's why I say you don't want to get the jury thinking about what's grooming. Was she groomed? Did she leave willingly? There's no purpose in having them go over that in their mind.
Unless you're going to allow that theory to go unrebutted.
Right.
Like that's the whole reason why you're calling her. If the state is going to put forth that theory that, okay, she left, they were in a relationship, okay, and as disgusting as it may sound on its face, you may have a juror to be like, all right, well, because like we were seeing it early on when this case was starting to kind of make news. Well, did she leave willingly? How did she get out of? I'm like, don't you remember me screaming about it in the beginning of Lives? It doesn't fucking matter how she left or why she left. The fact of the matter is she was groomed, and it wasn't something that she was able to control because this guy had his hooks in her. So whatever reason she leaves the house to me is completely irrelevant. But the state's going to argue, and if they're going to allow it to go unrebutted by allowing this expert to come on and explain exactly what grooming is, and this is how powerful it is over, particular kids of a particular age. I don't know what to tell you, man. It's like, to me, it's fucked up.
And again, I equate it to, on a different scale, them trying to say, when you say to a child, "Hi, I have a puppy in my car. Want to come see?" And the kid gets in the car and you slam the door, that they came willingly. They came willingly.
Right. That's old school grooming. That's pre-internet grooming. Like now, grooming is like taken on a life of its own because of the internet, because of the ability to access children via the internet. Like it's become like this nightmarish scenario. Whereas back in the day, that was it. Hey, you want some candy? Don't take candy from strangers. That was old school grooming. Yes, it was very short term, but it was effective. And it was so effective that we had to start teaching our kids in school, don't take candy from strangers. Now it's progressed way, way beyond that because of the ability of predators to be able to communicate with our children via the internet or
I'll be right
via
back. Keep
gaming
talking. I just need
devices.
water.
All right. Well, I'm going to start reading
No,
this.
because I don't wanna miss it, and I don't have my phone. Usually, I
Well,
I listen while you're continue ranting.
I mean, no, I don't like. All right. Here's what I'm going to do. I want to start going through some of these supers. All right. I left off with DB. Thank you, brother. Say less, fam. Appreciate the support always. Pammy, we love you. Great to see you. I love, love, love the hard starts. Keep it up. Thank you. I mean, YouTube has forced our hand, so I'm going to have to do it. Sherry Rain, safe travels. Thank you so much, both of you, for your support. We appreciate it and happy to support your efforts. Go Ducks. Quack. Oh, so you're talking about the Indiana? Like, are you really rooting against maybe the greatest like story in the history of sports? Like that Indiana University football team story is like Hoosiers on crack because it's college. But yeah, I mean, I don't really care about Indiana, but I'm rooting for them because it's like that story is amazing. But thank you so much, Ann. And for you, I hope that Oregon wins, but only for you, just because I want you to be happy. Dr. Vonda, thank you so much for your consistent and never-ending support. We always appreciate that. Dr. Russell's gasp. Throwing 5 at us. I really appreciate your coverage, covering this case, and I'm looking forward to your coverage. Well, thank
You're
you.
not highlighting it.
Oh, oops. Thank you for that. Classic overthinker, Aaron Spencer Travel Fund. Thank you. Meta glasses. Good idea. So
No, illegal.
oh, I thought that was for the on the street shit.
Oh, I think
Like
it
in
was me
the
saying I'm gonna
courtroom,
bring in
like, we
the
wouldn't be able
recording.
to show it. We'd get like flame thrown. Oh, we have secret video. We secreted away some video of the
I
courtroom.
know, but classic overthinker's joking.
I know. Or for the on the street shit. That's what most creators use those things for. All right, we'll pick these back up. All right. So let's get into so again, we have the motion where it was denied in part, it was granted in part, and the defense team has filed a motion to reconsider exclusion of Carrie Landau's expert testimony regarding SA of minors. Okay, so comes now the defendant. Wait, hold on. Let me get this thing unscrolling.
Oh,
Forward irritation.
gosh. I should have
Okay,
taken some more naproxen while I was up there.
we'll run up there.
No, I'm all right.
Okay, comes now defendant Aaron Spencer buying through his attorneys at Lassiter and Casanelli, and for his motion states expert testimony about the dynamics of child exploitation and how offenders use grooming tactics to abuse their victims has been repeatedly held admissible, citing a couple of cases, 2021 case and we didn't get the date on Pond, which affirming admission of expert testimony about the grooming process and how Pond had groomed his minor victim in that case. When this case presents, while this case presents an unusual fact scenario, the testimony is admissible and necessary to ensure that the jury has all of the relevant information and that Spencer is afforded the due process that is guaranteed to him. The defendant therefore asks the court to receive the material herein and reconsider its prior ruling, which was made without any substantial information as to the anticipated expert testimony. That's crazy. Like she didn't even want to hear what the hell. She didn't want an offer of proof to hear what the
Right. I
hell.
was going to say that the another part of this, at least for this particular one, if it has reports attached, is to pad the record for an appeal.
For sure. All right. So, despite this case involving a murder charge rather than a sex offense, the case law substantially supports the admission of evidence about child SA, specifically including grooming, and it is highly relevant to an understanding of Spencer and his daughter's actions leading up to and on the night of the alleged criminal act. The evidence is relevant to understanding Spencer's daughter's actions in leaving the family home to meet with her SAer and Spencer's concerns that she was in imminent danger, even if she did not realize it. Now, there's a footnote here. Fosler was charged with 2 counts of internet stalking of a child. that results in meeting with a child under the age of 15, a Y felony, 2 counts of SA in the 4th degree, a D felony, 2 counts of SI with a child, a D felony, computer CSAM, a B felony, and 36 counts of CSAM, a B felony, each one. The evidence of these offenses was indisputable. In addition to violating any order not to have contact with minors, Fosler committed and attempted to commit these and other criminal offenses after his arrest and on the night of October 7 and the morning of October 8, 2024.
So I don't like that they seem to be admitting that she left.
I mean,
I guess if that's what she's going to testify to, it's what she's going to testify to. But again, that doesn't mean that it's what Spencer understood to have happened.
yeah, I mean, either way, does it matter?
Legally, no.
See, but that's the thing. That's where this becomes a critical motion.
Well, that's what we have to see if they say what you said, babe. If they put all that stuff in there.
All right. So the testimony will clearly help the jury understand the evidence in the case. And that's Arkansas Rule of Evidence 702. It is essential that the jury understands certain dynamics of the child SA in order to properly evaluate the evidence regarding the events leading up to and on October 8th of 2024. The state has suggested that the minor was not being victimized and was not in imminent danger on October 8th of 2024, pointing to her having, quote, snuck out of the house with Fosler that morning and had, quote, not actually been kidnapped, end quote, and through her communications with Fosler and others, including her initiating contact with him earlier in the, quote, relationship and in reestablishing contact after his arrest.
I am disgusted. I am disgusted. And I know that's what you keep saying as well, but she's making the point that you were just saying, that if and hopefully she fleshes it out a little bit more, but if the prosecution's going to be allowed to present that factual scenario, which is disgusting and not true. I mean, not true. You're still kidnapped, because if she left with him, she presumably didn't know that he intended to sexually her or potentially unalive her.
I mean, apparently Judge Elmore doesn't have a fucking idea what grooming is. That's the way this appears to me. Sounds like she needs to have an offer of proof just so she can learn what the fuck it is. Because she's sitting there like a goofball on the bench, not knowing what the fuck I mean, for her to make that statement that this case is not about SA is like mind blowing.
It makes because he has the right to protect her against an SA. So how could it be not about SA? That's one of the potential justifications in defense of others. Imminent SA. What like my mind, I want to explode.
And there's a history of it, a known history. Granted, he wasn't convicted of it yet, but it appears there was some pretty powerful evidence that it happened. So, I mean, take that for whatever it's worth. Okay, so, and in reestablishing contact after his arrest, the jury should be permitted to hear from a witness who can provide testimony based on specialized knowledge, training, and experience to assist them in understanding the evidence about SA and contextualize the interactions that led to the event ending Fosler's life on October 8th of 2024. While Spencer was aware of some of the dynamics of child SA, like grooming, and learned more after Fosler's July 2024 arrest, he is entitled to present the jury with evidence from an expert who can provide reliable and articulate testimony to assist the jury in evaluating the claims made against him. The defense has proposed Carrie Landau provide such testimony. Landau is a 21-year veteran of the FBI, where she primarily worked on crimes against children cases involving the exploitation of minors, including sex trafficking. She has worked in the field of SA abuse of minors since 1996. She has conducted well over 1,000 interviews involving the exploitation of minors, including interviewing hundreds of victims and hundreds of offenders. She has received more than 1,000 hours of training and instruction in the investigation of crimes against children from various agencies, including the FBI, the Department of Justice, and the National Center for Missing and Exploited Children, among others. She has provided training and education to law enforcement officers, social service agencies, healthcare workers, attorneys, parents, and school staff across the United States and internationally. She has provided expert testimony on these topics many times and continues to work with child advocacy centers, other nonprofits, and state and federal governments, group and task force to improve investigations, develop standards and protocols for law enforcement officers, and improve services to victims. As the expert witness, Carrie Landau can explain offenders who SA children use manipulation, power, and control to gain access and compliance by minors. They target minors who are vulnerable and who and often have boundary issues, feel lonely or misunderstood, or have self-worth issues, aligning themselves with the child's feelings and distancing others in the child's life. Minors struggle with a limited understanding of sexual boundaries and are more trusting of adults, desire the approval and affection of adults, and struggle to identify manipulation by adults. Offenders bring the trust of the minor through attention, build the trust of the minor through attention, flattery, concern, and kindness, and create dependence, with the child becoming convinced that he or she is a part of the decision-making process and desensitizing the child to the sexual depravity they experience when in person. The grooming go ahead.
I just need to chime in and restate this point. To me, the defense leaning into this and making it make one bit of difference by the fact of having to put on an expert to explain this issue to the jury when it does not matter. It does not matter.
You keep saying that, but they're going to allow the state to come with this fucking bullshit theory. Like, how do you say
but
that?
I still think
it has to be rebutted. You and I would be battling this to the death. There would be I'd be screaming from the rooftops. If she's going to let the state come with this theory, we have to rebut it. You can't let it go unchecked. You can't.
But the way you let it go on, the way you can check it is to say that after my daughter spoke out about this and made it clear that in a million years, the mother, the daughter, the father, any one of them.
The 14-year-old victim who's getting re-traumatized is going to say it.
Well, forget her, the mother or the father, to say that after she came
so
forward
now
with this,
we're blowing apart Aaron Spencer's fifth.
What? You don't think he's testifying?
I have no idea whether he's going to testify, but you're forcing him to testify by not allowing this expert to come on to rebut this bullshit.
Okay, I'm assuming the guy's testifying, but I guess mom could testify. I mean,
as to what?
All right, let's just assume he's testifying, and he can testify that not in a million years after my daughter came forward and she was so traumatized by this and everything she went through and how she felt once he finally got charged, not in a million years did I think she left that house with him willingly, by manipulation, by whatever. Not in a million years. Once I saw that car with him in it, and I thought back to the barking dog, I realized in my mind, I was convinced he took her from that home by force, by drugs, whatever.
You're turning that into an issue that could go either way. That's scary to me. I'm going to assume that the state's going to argue this thing the way that they're claiming and the way that I thought that they would the last time we had this debate. You have to rebut it. Like, Allie, I want you to think of an 80-year-old farmer from fucking Lonoke County sitting on that jury who's never heard of the term grooming in his entire life, ever. And they're going to be coming at, if you let it go unchecked, how are you rebutting that? That old guy's going to be like, well, fuck, she left with him. I don't know. He's a little bit nasty, yeah, but she left with the. You have to rebut it. You have to rub up. Like, I just, you're never getting me off that.
I don't know.
She's allowing them to bring that theory that the kid left willingly.
I think that the
That's
judge should exclude how she left because it's
oh, she's
irrelevant.
not. She's not.
But it's irrelevant.
She's
It's
not
only
excluding
relevant
it.
what he thought.
You're preaching to the choir, babe.
What a reasonable person would have thought under those
You're
circumstances.
preaching to the choir. As I've said, to me, none of that shit matters. How she left the house is completely, I agree 100%. The fact of the matter is it's coming in at this trial. Like, we know this. She's not starting the clock at the time that Aaron Spencer laid eyes on his daughter in that dude's truck. She's starting it with when she left the house. To me, this thing, like, again, I'm going to ask you, imagine an 80-year-old farmer from Lonoke County sitting in that jury who's never heard of the term grooming, has no idea what it means.
I think that farmer is not going to give a shit about anything other than this man took his daughter from her house and was speeding away under the cover of darkness, and he damn well could have protected her however the hell he want. If he's that, you know, but I hear what you're saying because a lot of people do have said, but did she leave willingly? Did she leave willingly? That's why I think what is the most important thing, and I wish we actually went to the thing on December 25th to know, has anyone said the words, Your Honor, how she left is irrelevant. It should be inadmissible because it only matters what a reasonable person in Aaron Spencer's position would have thought. And whether Aaron Spencer was reasonable based on facts. And again, even if he's not going to testify, mom could testify that she, once the child spoke out about this, she became fearful of him. She didn't want to see him, whatever, all the things that she probably said or things to indicate to someone, well, I never would have thought she.
I don't think I am wrong, Mary Romaine. And I'm going to base that on 20 plus years of experience.
No, he doesn't say you're wrong. She said, Bob, it's wrong, but the jury will hate.
I don't know that they will. You cannot make that assumption that there's not going to be some older jurors that are very set in their ways. And I don't know how shit works in rural county in Arkansas. Like if they hear, oh, well, she came out on her own free will, not understanding that this wasn't on her own free will. That does not exist when she has been groomed. That's the point. Nothing that she did was of her own free will. She was coerced unwittingly. It has to be explained to them. I'm going to die on that hill. I'm going to die on that hill. That alone could send him to prison. That fact alone. And you've seen it. I saw it with people that I'm assuming aren't 80 asking the question, well, did she leave the house willingly? Like, dude, no, you cannot leave that to chance. In my opinion, in my humble opinion, that is a scary proposition, and I'm not willing to do it. Like, thank God they filed this because
Dr. Vonda's asking, what do you mean by rebut? Bob's saying that the state, just like this motion said, is going to say she left willingly. She was in contact with him. So that's what Bob is saying needs to be rebutted. The state's contention that like, oh, this was normal and she left him willingly.
Relationship. They like literally used the word she's in a relationship with a 67-year-old predator. Like, these people, like I don't even know how a prosecutor who's wearing a white hat types those words in relation to that particular scenario.
Me neither. It's disgusting.
How do you write the word? Oh, how should I describe this thing that was happening between this 13-year-old girl and this 67-year-old pig? You know what? I'm going to call it a relationship.
And what about the next defendant who wants to say, well, sometimes this state calls it a relationship. Hey, didn't you call it a willing relationship in the Aaron Spencer case?
Dude, yeah, I don't know, man. I mean, that's why we're going down for this. This trial is important. so important. It really is. And like I'm just dead set on it. And like no one's gonna change the way I think about it. You know, they're just not. Because frankly, I can't think of a scenario in which testimonies are going to come out at this trial that I'm ever thinking about this case in a different way. And that's just where I'm at with it. All right. So because I want to read this again. Like, this is exactly what a jury needs to hear. These words. Minors struggle with limited understanding of sexual boundaries and are more trusting of adults, desire the approval and affection of adults, and struggle to identify manipulation by adults. Offenders build the trust of the minors through attention, flattery, concern, and kindness, and create dependence, with the child becoming convinced that he or she is a part of the decision-making process and desensitizing the child to the depravity they experience when in person. The grooming process can be subtle, but creates a dependence that the child views as a loving relationship instead of abuse. It is common for the minor victim to initiate or reinitiate contact with the offender, to seek out the offender's love, concern, or forgiveness, and to express remorse for trouble caused by discovery of the relationship. That is what happened here. There was an outcry. She fessed it up. She went through a CAC interview, and yet she still communicated with the guy. That is the depths of this. It is so important that a jury is made to understand exactly what this shit is. It's like you were sitting there in the room when I asked my dad, I'm like, Dad, have you ever heard of the term grooming? He's like, oh, you don't want to comb my hair? No, Dad. Not when you comb your hair and trim your mustache. Not that. Not that kind of grooming. It's like he has no idea, and you have to assume that there is a huge amount of the population that doesn't know what it is, especially boomers. Boomers aren't going to know unless they're in the field, unless they watch true crime, unless they're consumers of the shit that they're just not going to know. And they have to be taught. It's imperative. It's an absolute imperative in my world. I would fight to the death on this thing. Like you want to see me in action, like losing my shit in a courtroom. I'm fighting on this thing to the death. And I get what you're saying. I really do. But the fact of the matter is the judge has made it relevant by allowing them to come forth with this bullshit theory that it matters that she left out of that house willingly. Whether she did or she didn't, I still don't know that. And I like, you're right. I mean, in this motion, they're making it seem like they've conceded that point. I don't know where the truth is in it. And you know who else doesn't know? Our Aaron and Heather. They don't know either because they weren't awake when that kid left the house.
At least they didn't at the time.
At least they didn't at the time.
Which is all goes full circle back to is all that fucking matters under the law. What he knew and what was reasonable to believe. And I'm going to say it one more time. Post outcry, I think there's enough information can put to that jury.
Where's that motion? Where's that motion in limine to bar them from bringing that bullshit? Because it doesn't matter.
Because legally it doesn't matter. I've said that before. That should absolutely be a motion that they file. It's too late to bring any motions.
Yeah.
They can object at trial to relevance.
I mean, they better. Okay, so the grooming process can be subtle.
You're at the appearance of
it's okay. It all bears repeating. It really does. The grooming process can be subtle, but creates a dependence the child views as a loving relationship instead of abuse. It is common for the minor victim to initiate or reinitiate contact with the offender, to seek out the offender's love, concern, or forgiveness, and to express remorse for trouble caused by the discovery of the relationship. The appearance of willingness or desire by the child does not change the abusive nature of the interactions. The grooming and manipulation create a bond between the abuser and his victim that render the child unable to identify the danger presented by the offender. Instead, the child feels sadness, shame, and self-blame for failing to protect the offender, as the offender in the child's mind has protected the child. Evidence of this nature is not within the common knowledge of many jurors. Grooming is a, quote, subject about which layperson would have little or no experience. The expert testimony is relevant in that it provides the jury with information about how research and experience shows abuse of a child oftentimes does not occur all of a sudden. And that comes from a 2009 case. Discussing the national acceptance of expert testimony concerning battered wife syndrome to help the jury understand the evidence. Such testimony can help explain the perception of danger, dispel misconceptions about the patterns of abuse and response, and make it easier to understand the overall context and dynamics of the abusive relationship, contextualize the circumstances, and assist in evaluating the reasonableness of the defendant's actions. I mean, think of a world in which battered woman syndrome didn't become a thing.
Right, and you couldn't have an expert explain it.
I mean, try to imagine that world, that we still lived in it. I mean, this is the new battered woman syndrome. It just is. All right, so
Then they cite a 2017 case for the proposition that discussing and citing cases regarding expert testimony concerning battered spouse and battered child syndrome as helping the jury to understand perceptions and behavior at the time of the killing and relevant to reasonableness of act. Do the same for the 2021 case?
yeah.
Oh, and then they cite to this New York 2021 case, collecting cases nationally where this type of testimony has been approved and explaining that opinions regarding child SA and grooming may assist the jury in understanding how a minor may be enticed, induced, or coerced into illegal SA without physical force, and may also assist the jury in assessing evidence that some alleged victims repeatedly interacted with Jeffrey Epstein, seemingly voluntarily, even after they suffered abuse. And then another 2017 case in an Eighth Circuit, which is the circuit that Arkansas is in, and it's collecting numerous cases in the Eighth Circuit, which again is their circuit.
Do you want me to read?
Yeah.
In this case, the circumstances and characteristics of the abusive relationship, in quotes, between Fosler and Spencer's child are consistent with what are commonly seen in cases of child SA exploitation. Information about the dynamics of these relationships, specifically grooming, will assist the jury in understanding evidence of a 14-year-old girl's continued contacts with her SA and her failure to appreciate the danger he presented. The testimony will help explain the perception of danger, dispel misconceptions about the pattern of child SA and responses of the child, make it easier for the jury to understand the context and the circumstances presented, and assist in evaluating the reasonableness of Spencer's actions.
So that right there is an important fact, that it was necessary.
Wait, are you implying that everything else I've been screaming about isn't?
No, I'm sorry. I did not mean to imply that, but that is one of the most legally
about to duke it out.
Right, legally effective arguments here is that it assists in evaluating the reasonableness of Spencer's actions, because for all of those reasons just said, assuming that he's going to say, and it sounds like she said that he learned more about grooming right after this guy was arrested, that he's going to say he knew his daughter was in no position to protect herself, to recognize the danger that was presented by him. So that makes his actions more reasonable, because someone may say, well, if she didn't want him to do it, she just, like someone that's still thinking the way that you're mentioning, babe. Well, if she just didn't want him to do it, then they wouldn't have done it. There's no allegation he was going to force her. There's nothing to say he physically forced her. So that does go to his reasonableness of his behavior, um, of his knowledge that she is at imminent risk and unable to protect herself from it, unable to appreciate it. So that goes against everything that the judge might be thinking on every other issue. Although I see your point on all those issues as well. I think that's the strongest.
Well, I mean, that's the one that gives her the connective tissue,
Right.
you know, whereas, and whatever, if that's got to be the connective tissue to get all the rest of it in, which that jury has to be educated about, they have to be. You know, if she needs that connective tissue between Aaron and Spencer, I mean, the question becomes like, if I'm Aaron and I have no idea what grooming is, I never heard of it, and I'm trying to understand in what world is my 13-year-old putting herself in a position to where some creepy old fuck is able to get her into a position like he was able to, and I'm trying to understand it, and then I educate myself or I see to trying to understand how that could possibly happen in what world, and then I know, like leading up to the 8th,
So, but
then
now think of it from what I said before. It goes against what I'm saying, which is after the outcry and after he was arrested and she came to terms with all this, not in a million years did I think she would have left with him willingly. Now you have all this grooming stuff to say, "Oh, well, I guess he did know she might leave with him willingly or without force because he knew that she was being manipulated, brainwashed, whatever the case may be." I don't know. I see issues with it.
I
And
look,
I
I mean, that could be a slippery slope if they're able to establish that somehow either Aaron and or Heather was aware that he was communicating with her prior to that date. And I'm talking about post bond. Like
Well, and
if
I
like,
don't think that that's I don't think that that I would it would be better that they were not aware that they were
well,
continuing
no
to communicate.
shit.
Right.
Yeah, duh. Obviously, it's a major problem if they
If they
have
kn
if they have some kind of evidence that
they
Aaron
knew ahead of
knew that
time.
like he'd grabbed her phone
Well,
and
then, yeah, if that's the case, then I would say that this evidence uh, doesn't hurt in the way that I think that it could hurt. And I don't know if we're losing people on our thinking on this, but hopefully they're following what
what's
we're
losing? Oh, you mean no? I mean,
yeah, because we're kinda
we got some smart
take
people
the
in this.
next logical right.
We've got
That's
some smart people in this community. I think they're right there with us. If I had to guess. All right, so back to the body, as my wife likes to say. If permitted to do so, Landau would testify consistent with the assertions above and below that SA in these cases is primarily about power, especially when the adult is physically, emotionally, and socially more powerful. The dynamics of power and control in the child SA cases are evident even when no physical force is used. SA cases are less about the actual act of S and more about the power, control, and exploitation of vulnerabilities of victims. When an older offender abuses a child, the age gap itself depicts a power imbalance. The lack of worldly experience for a child puts them at risk due to their lack of awareness and ability to sense danger, deception, and trickery. Children can be exploited due to a limited understanding of S boundaries at their age, and they tend to trust adults easily. And we all know that's so true. We all know that's so true. You know, kids want to trust adults, and they do. They really do. Um, so children can be exploited due to a limited understanding of the S boundaries at their age, and they tend to trust adults easily. Children desire the approval and affection of adults. It's so true. And they struggle with identifying manipulation by the same adults that they seek approval from. Grooming is the systematic, deliberate use of power over a child. Offenders are often groom children to make them accessible, vulnerable, and compliant, Predators involved in the SA of children use these manipulative tactics that are often referred to as, quote, grooming, to keep the children or child engaged and convinced that they too are a part of the decision making in these situations of abuse. The grooming of a child can include building trust through attention, flattery, or kindness, complimenting the child and paying attention to them, especially in the moments when the child feels that there is no one else doing so. Is effective, and even more so if the child feels alone or struggles with self-esteem issues. Once the child engages with the offender in conversations, this desensitizes the child and allows for more pervasive ways in which the behavior can continue once they're in person and alone with one another. This gradual but deliberate behavior is encouraging, convinces the child to comply with the request from the offender, and increases the likelihood that they will comply once the offender and the child are physically alone together. An offender may start the relationship with what appears to be an innocent touch or a small compliment towards the child about their body. This is a way that offenders begin to gradually test victims to cross boundaries and normalize behaviors. If the child provides nude photographs and or videos, the offender continues to push the boundaries. Praise by the offender often follows these conversations so that the child is reminded that they did a good job, made the offender happy, and have value. The tactics used by offenders in SA cases are often subtle. Victims often cannot articulate and have a challenging time identifying what is happening to them. Often, the tactic of confusion and dependence with the offender and victims go hand in hand. Physical claims are rare in these cases, but victims can become compliant and appear to go along with the relationship slash abuse. Therefore, no chains are required. Predators target vulnerable individuals, making it easier to control and manipulate them. They seek out those they perceive as less likely to react negatively to efforts at grooming and abuse, who have less access to people they believe will understand their situation and or who are less likely to report anything inappropriate to people who would intervene. They seek out children who feel misunderstood or involved in family conflict and or who are emotionally vulnerable and have trouble asserting boundaries. In the common instances in which minor victim may appear to initiate contact with the offender, it is sometimes difficult for adults to understand. The offender preys on the vulnerabilities of victims and youth with the focus on grooming and convincing them to become involved in what they believe is a loving, caring relationship. The offenders often prey on the confusion of teenage life and the uphill battle many young people face. Increased vulnerabilities often include self-esteem issues, friendship problems, fitting in, moving away from friends, going to a new school, and simple teen pressures. The victim feels dependent on the offender emotionally and appears to be the one initiating contact, longing for that connection that they believe is a real and legitimate relationship. Offenders often encourage children by telling them that they are a grown-up and that the offender offers to treat them as an adult, which is enticing to a child who may be struggling at home with parents and their rules. This assists in the child feeling as though they are in control and they are the ones making adult decisions. When the adult offender tells a child that he loves the child, normalizing the an emotional relationship and reducing the fear of consequences, the power imbalance is significant. If a child's first experiences with affection of any kind in a relationship outside of their home has been mixed with manipulation or deviant behavior, they may misinterpret warning signs and or the abuse may be seen as normal or familiar. Children lack the capacity to make informed risk assessments of anyone in their lives, much less an adult who is pretending to care for them. Offenders choose victims as a way in which to become the primary person in the victim's life. These victims feel, though, as they have been let down by others or feel misunderstood, When the offender shows them attention, it garners loyalty and dedication from the victim. The offender demonstrates a loving, caring, and agreeable relationship while manipulating and preying on the child's vulnerabilities. Offenders often frame SA with the child as, quote, a relationship and ensure that both are participating in a way that seems equal as to hide the true definition of this behavior, which is abuse. Offering gifts or privileges to create a sense of obligation and to normalize S behavior and reduce the child's ability to resist also occurs during S exploitation of minors. Offenders make promises of special outings with the child and often offer gifts or rewards to victims during their conversations. Offenders plan a future with victims to demonstrate longevity and promise that they will be together. Offenders often remind victims that they will never leave them and that they are in this together and for the long haul. Vulnerable teenagers who fear fitting in, hope for lasting relationships, and struggle with friendships and self-worth long for the promises of longevity, which is why this tactic works so well with teen victims. Grooming also includes the offender agreeing with the child and undermining the child's connections with people in her life who she may feel at odds with at that time. Offenders who side with the victim appeal to the victim's mindset and are adored by the victim for aligning with their feelings while working to remove protective adults in the child's life so that the victim relies only on the offender for advice and comfort. Offenders work to be indispensable to a child so that they become the primary person in their life, making the victim reliant on the offender. Many victims continue to express love and loyalty towards their offender even after being removed from the situation. Many victims feel shame, embarrassment, and are sorry that the offender got into trouble, and they blame themselves. Most minimize the number or extent of the abuse or activities in which they engage due to feelings of shame and embarrassment. It is quite common for a victim to reach out to an offender or attempt to do so after discovery of the abuse and even after an arrest. Victims often reapproach to apologize for their role in getting the offender into trouble and ensure that the offender is not upset with them. The victim's feelings of remorse, guilt, shame, and self-blame are common due to the gradual normalization of the abuse. They often miss the offender and still feel they are involved in a loving relationship with the offender. These behaviors by the victim are quite common, especially when a S relationship has developed and the trauma bond has been established.
So I wonder, because they mentioned multiple times reinitiating contact, reaching out, I wonder if we're going to see some of that here.
I mean, yes. Like, I think that that's the way that this thing went down. Like, I mean, like you said at the very beginning, it seems that they're conceding to the fact that she left the house without him coming in and taking her by force.
Right. But also it seems with what they're putting in, that at some point she may have reinitiated contact to make sure he wasn't upset with her.
Right.
Which has no bearing on this.
No
I'm
bearing.
Just saying, right.
No bearing.
No bearing.
But for that jury, who aren't going to be lawyers, it's got to be spelled out like that. Like all that shit we just read. That's exactly what they need to hear. They need to understand it. I'd like to read it to my father so he understood it.
I think he understood it once we told him.
I don't know.
He's not inept. He's,
I don't know.
Pretty good criminal lawyer.
He was a great criminal lawyer. The defendant seeks admission of Landau's testimony based on her experience and its relevance to the precise and substantial issues in this case. Although Landau has reviewed the evidence in this case, her testimony need not address the specific evidence in this case. And unless the court or state seeks such testimony, the defense does not intend to do so. Alternatively, Landau is prepared and qualified to apply her experience to the facts of the case and testify accordingly. Footnote 2, to be clear, Landau can, but need not testify about the application of her experience to the facts of the case. Landau is qualified to testify relating to her experience to the facts of this case, or to testify in a general manner as to the SA exploitation of children. The defense offers her testimony without reference to the specific facts of this case, but defers to the court as to the scope of her testimony in this regard. If the state and the court prefer her to discuss the specific circumstances of this case, she will do so. To be clear, the defense seeks admission of her expert testimony either way, both with and without her addressing the specific facts and evidence in this case. It is the defense's position that both are relevant and admissible, and thus the defense seeks admission of her testimony either with or without including her opinions as to the specific evidence in the case. All right. Okay. Landau's testimony will assist the jury in understanding why Spencer's daughter appeared to go along with the quote.
No, wait. Are you sure you're on the right page? I thought.
Yes. Yes.
Okay.
I just got to footnote 2, remember? Right there. See the period?
Oh, yeah.
The last sentence. Landau's testimony will assist the jury in understanding why Spencer's daughter appeared to go along with the quote relationship with Fosler. Expert testimony about grooming is certainly admissible if a party argues that a child abuse victim's conduct is inconsistent with abuse. And that's from a 1992 case.
And that's the point that you've been making, that if the judge is going to let the state present it as a relationship and she left willingly, then they need to be able to rebut that.
Indeed. Any suggestion that Spencer's daughter's conduct was inconsistent with being a victim of SA, or inconsistent with being at risk of being victimized, or inconsistent with her having been groomed for SA certainly renders this expert testimony highly relevant and admissible. It is admissible on its own, but it is certainly admissible if the state suggests, as it has in its pretrial pleadings and conversations between counsel, that the evidence is inconsistent with Spencer's daughter being a victim of SA leading up to and on October 8th. Are you fucking kidding me? Holy shit, dude. I could not imagine having a conversation with this guy like in good faith.
I'm dumbfounded.
Does this guy have a fucking daughter? Does this prosecutor have a daughter? Like what in the wide world the fuck is going on here in Lonoke, Arkansas?
It's like really giving them a bad name.
Holy shit, man. Oh, good God. With her being at risk of further victimization, or with her having been groomed by Fosler before and during this time period, it is also certainly admissible if the state suggests in any way that her communication with Fosler or others, or her, quote, sneaking out of the house, end quote, to go with Fosler indicates that she was not a victim, was not groomed, or was not, by her own conduct, at risk of further harm. A primary issue in this case is whether it was reasonable for Spencer to believe that his daughter was in imminent danger when she left her residence with the S predator accused of S abusing her, in violation of this court's order, while that predator was attempting to commit and fleeing from the commission of the very same crimes he stood charged for having committed against her. The evidence is admissible to assist the jury in understanding the evidence related to Fosler's grooming and abuse of Spencer's daughter. Her actions and the actions of other witnesses and Spencer relative to these events, it is relevant to the jury's determination of Spencer's mental state and as to the jury's assessment of the reasonableness of his belief that his child was in danger, despite her apparent willingness to leave her residence with her abuser. That addresses your concern.
Yeah, I would have right, assuming that, as the state seems to imply.
Okay.
That's what I would have added there, as the state seems to imply.
I get it. It is clearly relevant to the unusual facts at issue in this case, and the failure to permit such testimony violates Spencer's right to present a defense consistent with due process guarantees and will deprive him of a fair trial, all in violation of the United States and Arkansas constitutional guarantees. Wherefore, defendant Aaron Spencer respectfully requests this court reconsider its ruling and permit Carrie Landau to provide expert testimony at trial and for any and all just and proper relief to which it may be entitled. So there's that. So that catches us up to speed in terms of what we got going on filing wise. So
before we go further, I just want to say that Okie Angel, now I remember she said she was going to get surgery and she got that ice machine and it made a difference, but she said she had a rough time within 2 days after she was back in the hospital with pneumonia and sepsis.
yikes.
Wow. Feels
Sorry
good
to
be
hear
back
that,
home.
Okie.
Glad you're back home.
That's awful.
I don't know, people. We can't be the only people outraged by this. I can't imagine. I need to know what the guilters are saying, that they think this is all okay.
Are there guilters out there? I don't know that
I
there's guilters. I think that there's people that they want to hear all the facts. I don't think that there's anybody cheering for Fosler, but I think that there's people that want to hear all the facts of the case come out at trial.
I think they've heard enough in that last motion where it went through like step by step what happened. Even if you go on the state's theory,
I mean, there are going to be people that don't believe that Fosler merely getting out of the truck was enough.
And when I say we, I mean the royal we, all of us in this community here on this live and in this chat. I know y'all are equally outraged. I'm just saying what's going on in the rest of the world, because I can't imagine there's anyone who feels differently.
I mean, at the end of the day, we don't matter. It's the 12 in the box that matter, you know?
Yeah.
All right. Okay, let's get back to the supers. Kay Helly, $5 holla. Appreciate it. Always. Auntie Sherry, thank you for doing this. My pleasure. Well, like we're more than happy to do this. Like, these are the cases that we think are important. I don't want to diminish Karen Reed's civil case, but we're in the criminal realm. Like I don't know.
We'll cover that too. Are we not covering it? We're covering it.
I don't know. Like, I don't care about money. I care about people's freedom. I care about the Constitution.
I know, but more facts might come out.
Yeah, I mean, if we find some fascinating shit that seems to lead back into the criminal realm, it's a different story. If it's all just about money, I don't know.
All right.
Like, there's other shit. There's a lot of cases I want to follow. Like, we all know that Sarah Grace got kicked down the road to August, but Corey Richards is coming up, and there were a couple of people that were throwing some cases that are going on now. A Jersey case, babe. Your old neck of the woods out there. Sounds like a pretty interesting case that I think they just picked a jury. But what we're doing before any of that is we're going to do a rewatch at probably 1.25, maybe a little faster, depending on how it sounds. We're watching Zach Adams, the Holly Bobo trial. It's 9 days. I think we could probably get it done in 4. Being able to fast forward through shit that's we don't need to listen to, getting right to the guts of every witness's testimony and see what's what with that case. We owe it to you guys. You guys need to see it, and I want to see it.
I might have to leave you, go get medicine and get some ice on myself.
I love you very much.
I love you guys. I love you, and I love everybody.
Okay, bye, baby. We'll see you tomorrow. See you tomorrow. Same bad time, same bad channel. All right. Post-Punk Mama, member for 16 months. Oh, gee, we thank you so much. We adore you. Use my trivia game win for your travels. Interesting. Yes. Yes. JoJo's grave concern. Aaron Spencer for sheriff. Drop the charges. Agreed. Think that ship has sailed, though. This thing's going to trial. But thank you for that. Bailey B. Appreciate you. Justice for the Spencer family. Thank you all for covering as always. Go Bears. My teams are out. I'll cheer for the Mata household happiness. Thanks. Appreciate that. And your constant support, Bailey. JoJo's Grave Concern comes back with another 5 boots on the ground. Thanks for covering this, Bob and Allie. Yeah, I'm excited to get down for it. I mean, the first trial that I ever covered where I wasn't the lawyer was Rick Allen's, and it was such an unusual circumstance, like to be sitting on the other side of the bar, but it was fascinating. I enjoyed doing it, and it's going to be great to have somebody where I'm not trying to write down every word, because like I always want to give accurate information, always. Like I like if I were a computer and could just soak it in and just puke it back out, then I'd read you the transcript, But we'll do the best that we can, and it'll be helpful to have Allie there, that's for sure. But thank you for your support. And then Steffi Ann, is the trial in the county that the shooting occurred? Yes. I don't know. I don't remember seeing a motion for a change of venue. It always befuddles me. But in this particular case, I could see wanting to stay in the home court if you're Aaron Spencer. Like, I mean, if they're out, like, but the state has every opportunity to file the motion for a change of venue as well. Like, this is a small town. Cabot's a small town. Lonoke's not a huge county. There's no huge towns in Lonoke. So, people talk in small towns. Like you're going to have a pretty good idea which way the wind's blowing if you're Aaron Spencer and the Spencer family. You're going to have a pretty good understanding. People got you on this one. They behind you. You're going to know. You'd think that the state would know that they're not behind them. That's what I want to get down there for. I really, the man on the street shit's going to be great. I'll get people talking. I promise. I'm good at it. Like it's going to be great content, and it's going to be interesting. It's going to be the people that matter, the people of that county. Thank you so much for your support. Iceman Cometh, always great to see you. Great to see you guys, and happy to help with the goal when I can. You always help, Iceman. You're incredibly generous, and we're always incredibly grateful for that. Thanks for all you do, and thank you for all that you do. Military Mama supporting Bob and Allie always, and of course, Aaron Spencer. Appreciate you, Military Mama, very, very much. Kasha, thank you so much. Happy to help fund snacks for Boots on the Ground. Appreciate you, Kasha, for many, many reasons. Tracy, I love you so much. Boots on the Ground, appreciate you, girl. Thank you so much for everything that you do. NR, FU4GS. Is that like your robot name? Hi, Matas. Can I get a shout out or words of wisdom from my daughter, Svea, 14, future defense attorney? Thanks. Absolutely. I'm so excited to hear that. If she's listening, we need you. Believe me, we need you. You are the one that's protecting the Constitution. Don't let anybody ever tell you differently. You're the protector of the rights of the citizens of this country. If you take up the defense bar and decide that that's going to be your career path, you're the good guys, and you're fighting for the good guys. And don't get lost in, some of my clients are guilty. Yeah, well, those guys plead out typically. Typically, they have the evidence. Because every once in a while, there's a case that requires fighters, people that will fight like hell to protect our rights. And that's why we need the next phase. We need the young heads coming through. So I hope that you stick on this path. I hope that you continue to watch us over here. Just earmuff all my bad words, and but take heart in what we're saying, because we really do. We need a whole new brigade of young people who want to do what we do. And we spent 2 years trying to educate people on what it is the defense attorneys really do. I'll be curious someday. I'm going to ask Aaron Spencer what his feeling on defense attorneys was prior to needing one, and where it's at now. Those are great interviews. I'm not going to assume Aaron had any kind of feelings one way or another, but if he's like most people, who don't really put much thought into it, or just like, defense attorneys are scumbags, are trying to get criminals off, and that's as surface level as they're at with it, you find out in short order just exactly how important we are. So that's great to hear. Thank you for alerting me to that and for your generosity. Crystal Rice, $5. Glad you guys will be there to keep this in front of the public. Looking forward to your coverage. Appreciate that. Yeah, we hope you guys will spread the word. Like we got 527 in chat from YouTube. Get it out there. Let the people know. Let the people know. Like I don't know that anything that's going on in the end of January that's going to be more significant than this in any courtroom in the country. So spread the word. Do us a solid. Thank you so much for that. Breezy Girl, 313. Love to you both. Here's to Boots on the Ground. Thank you so much. We appreciate that. And I promise this money will go exactly to that. DK, member for 7 months, evenings with Bob and Allie, my favorite. Thank you for breaking this down for us. My outrage matches you, Allie. The prosecution is frightening and scary. For real. That's both of us, not just Allie. Thank you so much for that support. SOAP, API. I would also argue that having the child explain this on the stand would be an error. Yeah, no, that's not. No. She will be years older than she was at the time. No, actually only a year. Well, maybe two. But just re-traumatized nonetheless. No, maybe going on 2 years older. She will be years older than she was at the time, which gives a false sense of her true youth when she was being essayed. That's a great point. That is a great point. Sky Goddess. Plus, you just don't want her getting into that. It's bad enough she's going to be re-traumatized, having to tell the story for all the reasons that we just read about in terms of the way that they're made to feel. And I'm talking about the victims, that they bear this responsibility, this it's so ingrained into them that they feel bad about outing their abuse. It's like, it's so warped. I feel so terrible for that child. Sky Goddess, Aaron Spencer Fun. Thank you. Safe travels. Appreciate you so much, Sky. Always. Disgruntled Pelican coming in hot with 50. Solid. Thank you. Thanks for the coverage on Aaron Spencer. Looking forward to the trial coverage. Happy New Year and love you guys. Right back at you, Disgruntled. Thank you so much for that incredibly generous support. Okie Angel, Allie bought an ice machine. Oh, she read this one. Thank you so much, Okie. And I'm glad to hear that you're doing better. Sincerely. Kay Helly, new member. Oh, family hug for you. Oh, there was somebody up here. Cape Cod Cred. Oh, family hug to you as well. Appreciate that. Always love having new members. It's a wonderful thing. And then Okie Angel, coffee and snacks while working. The people with boots on the ground. Appreciate you, Okie. And I think that we got a couple of Venmos. Got to shout those out as well. Okay. We did indeed get some Venmos came in. Our absolute Kim, our always giver, gifted us as always another $25. Thank you as always, Kim. You're amazing. Thank you for your continued support. Elaine, thank you so much. Looking forward to the recaps. Thanks for doing this. Absolutely. Our pleasure. And then Cherry, thank you. Spencer, thank you guys so much. I think I saw one Cash App come in also. Let me give the love there. And we got in a, let's see, where'd it come from? TLR, you guys are awesome. Thank you. We appreciate you so much. And I love your coverage. Thank you. That was a nice $10 holler. We appreciate that. And then I think Rachel for love this channel. That was all the way back before Christmas. I don't think I forgot to give you the love there. All right. So that's that. I hope you guys, got a new member. Kenda Ducote. Family hug. Welcome, 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 welcome to the fam. All right, y'all. We hope that you took something away from this. I think that it was an important live. We're getting very, very close to trial. It's coming. It's coming, and it is going. And I just think it's going. Oh yeah, Josh is on the same side. Yeah, but Josh, like, he's still got that prosecutor vibe to him. He does, and I love Josh, but he's got that, like, it's underneath there. It lurks, his prosecutor vibe. Yeah, I mean, I think anybody would be outraged, especially if you have kids. You know, it's an outrageous case. It's just one of those cases where, man, I don't know how you're charging this guy. So, all right, y'all. Tomorrow, keep your eye out. I think what I want to do, kind of the game plan is, I'd like to cover. We're gonna dip over to Rick Allen. I do want to address this this new audio that came out between Jerry Holman and Professor Turco, which is incredibly upsetting, as Nick McClelland stood in open court and in pleadings and called the defense flat out liars, saying that they were mischaracterizing what Turco said. And this interview that took place with Holman puts that all to bed. I mean, there's some people out there that should be ashamed of themselves. And I'm talking in the professional capacity, and I'm talking about creator capacity. Like, I mean, have some scruples. Like, doesn't the truth matter at all? Isn't that what it's all about? Or is it to sell books? Is that what you're trying to do? Because I took a lot of shit for 2 years because of what I believed about the Rick Allen case. And I was the only lawyer out here, along with my wife, obviously. Nobody was out here in these Delphi streets in terms of creators. We were it. And I probably lost half my audience because I took a position on that case. Oh, Bob's a child murderer supporter. I'm like, what the fuck are you talking about? So there's some people that need to be ashamed of themselves. And you know who you are. And I'm looking right at you. And like always, I'm always here to talk. Never hide from any of you, ever. Open invitation to my channel anytime. I mean what I say, and I say what I mean, and I stand behind it every fucking time. Every time. And it's that simple. So we're going to go back to, we do have the best Delphi coverage. That's a fact. You cannot understand the trial without understanding what happened before the trial. So, and I know I'm going to hang with brother counsel. I'm so happy Andrea went on with him, got him up to speed, got him enraged. He invited me on. I'm going over there on Sunday morning because fortunately the Bears are playing Saturday, and me and Martin are going to get into it more. I'm gonna keep pulling them in because we need it takes a village. It takes a village to get somebody out of prison that's wrongfully convicted. So be on the lookout for that. I'm sure we'll be putting some promos out for that. But yeah, I'll be with Martin. I think I'm going over there 11 his time. He's Eastern. And that'll be 10 my time, but it'll be great. And I'm always grateful that Andrea is able to get people on board. So, it's one of those cases, and I'll be telling him, I was coming over for Karen Reed 1 out of Delphi, and I'd seen the worst judge on the planet. So I'm sitting here watching people bitching and complaining about Canoni being biased, and maybe she was in some respects. I would have fucking killed to have Bev Canoni on Richard Allen's case. It's that simple. Killed to have her. They got in everything they wanted. Everything they wanted. So there's no comparison. And people are spending an awful lot of energy on Karen when she's been found not guilty. I'm putting a plea out there. Shift your passion. Shift your outrage to a case that deserves it. The more you hear about this case, the more it'll suck you in. And we need you. We need the eyes. We need the ears. We need the hearts behind it. We just do. Just listen to all the facts. I'm not going to try to convince you of shit. All I did was read pleadings for 2 years and fell off my goddamn stool while reading them. So, all right, enough of rant. I've done a lot of ranting tonight, but I've been off since before Christmas, or maybe before New Year's. So it had built up. A lot of rants had built up. You guys know me. Sometimes I just got to let it out, baby. Got to let it all out. But I love y'all. The last episode of my passion project, of the greatest thing that I've ever done on this planet, aside from marrying my wife and having my children, is buried inside the John Wayne Gacy investigation. I will put it up against any podcast on the planet. Telling you that flat out. Go listen to me and come fight me. Tell me which one's better. I'm just telling you. Go listen to it. The last episode dropped today. Episode 33, part 3. Tip of the cap to the victims, the 33 victims, known victims of John Wayne Gacy. It's everywhere you can get your podcasts. Scan that thing right there, that QR code. That'll bring you there. We got the links. The mods have been dropping it in, the entire live. Go listen to it, please. There is no podcast out there like it. You like interviews with all the players, got it. But you name a podcast that went in a case like that, one of the biggest cases in the history of American jurisprudence, and you're able to get, well, one was easy. My dad to perform his opening from the transcripts in its entirety, and then to get the prosecuting attorney, Bill Kunkel, to perform his in its entirety. We couldn't even use it all because it would have been a 4-hour episode. It's an unbelievable pod. The only people on the planet that have ever heard it, the closing argument that put Gacy down, is in the final episode of that podcast. So, and the story that gets you up to that is unbelievable. So I'm going to never stop promoting that because it deserves to have millions of listens. It's that thing. Like, I don't want to regret that I didn't go to Wondery and sell it, because it would have been 12 episodes. So I've just got to keep promoting it. I've just got to keep doing it. But all right, you guys, enough is enough for tonight. We adore you so much. Our mods, we absolutely could not do this without you. We love you. We adore you. We cherish you. I wish all of you a happy New Year, since I haven't done it yet. We are going to have a members only 60K party. I'm hoping to do it one night this week. And our Patreons, or patrons is what they call them. So both are going to be invited. Lieutenant Teletubby has sent me like an amazing list of games that I think that we could play together. That'll be fun. So like a ton of great ideas. I want to have it be like a game night where we can all just play games and have fun and celebrate each other and be happy and all that good stuff. So keep your eyes out for that, but then keep an eye out for when we're going to do this live on Rick Allen tomorrow. I'll let you know. I try to get it posted sometime in the morning, and I'll always post it on the community page. So you guys are amazing. Thank you. Thank you. Thank you for your generosity. I appreciate it so much. And so does Allison. And just remember this, without you guys, I am literally just an old man ranting to nobody but my beautiful and brilliant wife.